Hi, thanks for joining us this week on the Deposition. Here again with its senior attorney, Nathan Lewis.
Good to be here.
How's it going?
Good.
All right. Well, let's get to it. So there's a big story out of Nashville, Tennessee. So a woman came in from Colombia on a visa, which then expired. She later filed for asylum, which some people do, claiming threats and persecution back in Colombia. While that was pending, she got married to a U.S. citizen. Apparently, her U.S. citizen husband did file petitions for her, and she's in process to go for residency. Yeah. Now, she has a work permit through her asylum application, but that's what she has right now.
Right.
So she is a reporter for a local news station there in Nashville, and she was recently detained by ICE. They're claiming she was a flight risk because she missed several appointments.
Right.
I don't know if this is in regards to her asylum or in regards to interviews for her residency. We don't really know. But she is detained, and she does have attorneys that are fighting back against this.
Right.
But I think this is a very good lesson for people out there that if you do not have status in the United States, you are subject to detention.
And a work permit by itself is not status.
Correct.
So everyone thinks that, how can they detain me? I have a work permit. A work permit just allows you to work lawfully in the United States. It does not mean you're allowed to stay here lawfully. In this case, she was out of status when she applied for her green card. So because you're out of status when you apply for a green card, ICE can't detain you because you're still here illegally until you get a green card.
And a good point here is that having applications pending with USCIS does not grant you any protections.
No.
It does not grant you status. It does not grant you freedom from detention, anything like that. And we do have clients that sometimes show up to check-ins and things that are set. They're doing the right things, and ICE will still detain them. So you got to be careful out there.
Exactly. Or they'll detain you at like I-130 interviews, like with USCIS. That happens all the time. So until USCIS says approved, there is no protection.
So let's talk immigration appeals for a second. So when someone has a removal order, they typically have 30 days from the date that order is entered to file a notice of appeal with the Board of Immigration Appeals. Now, the Trump administration was trying to institute a new rule where it would give them only 10 days to then file that notice of appeal. We were hours away from that 10 days going into effect, but surprise, surprise, a judge came in and put an injunction in, so it remains at those 30 days.
Well, it wasn't not just the 10 days. The appeal itself had to be approved to be filed or moved forward, or it could be summarily dismissed. So the recent court decision stayed that 10-day rule and the summarily dismissing the appeal. Now, if I don't know if there's going to be an appeal decision, I don't know what's going to happen. It could remain like this forever, or it could be go back to 10 days here in like a year or so. Who knows?
You know, something funny you said. A judge put in that injunction on what day?
That was on Sunday. Yeah.
That's amazing.
Yeah, I've never seen a judge work on a Sunday before, so that was amazing.
If that 10-day rule does come back into effect, people got to pull the trigger a whole lot quicker here.
They do. They should be prepared to pay the filing fees with BIA plus any attorney's fees to file the petition like right away. There's no more waiting around a month to get this done. It needs to be done immediately.
Absolutely. So in Illinois, ICE arrested recently a non-citizen, and they're accusing him of voting in 7 federal elections between the years 2008 and 2020. Okay. Now, we know you have to be a U.S. citizen to vote in U.S. elections. And if you are a non-citizen and you attempt to register to vote or vote, big problems.
Huge problems. You registering to vote can be treated as a false claim to U.S. citizenship. That will forever block you from getting status in the United States. Doesn't matter who is sponsoring you. You're done.
So parents out there, make sure that you have all your documents lined up. You have birth certificates and things for your 17-year-old maybe that's going to be turning 18 and wants to register to vote. We just had an election season. That they can prove they are U.S. citizens, because if you even fill out that voter registration and send it in, bad things can happen.
Yeah, big problems.
So Kristi Noem, out. Senator Mark Wayne Mullen, in as head of DHS. Now,
lots of people complain about her.
a lot of people have complained about
on both
her.
sides, actually, of the aisle.
I think one of the issues here was when the Trump administration first got in there and put Kristi Noem in there, they had a big budget for this self-deport strategy where they were encouraging people without status here to leave the country and possibly even get some kind of benefits from doing that. I think there was some controversy there with her.
Yeah, the main complaint I've seen is that she was using this for self-PR purposes. Promoting herself,
kind of looked that way
over the program. I don't think the change is actually going to affect the self-deportation program. I could be wrong; it's still too new, but I bet their program remains in place.
And now they have Mark Wayne Mullen in there, former MMA fighter, kind of a tough guy, postures himself. I think this just fits the image that the Trump administration really wants to have in their leaders. Whether that changes anything, I doubt it.
Probably
I think
not.
It's just an image thing.
Exactly.
So down in McAllen, South Texas, for those who aren't familiar, there was 3 brothers that are mariachi music players that were detained by ICE recently. They came from another country. They'd filed for asylum, fleeing violence from cartels, doing everything they were supposed to do. Filing the proper paperwork, going to their check-ins like they were supposed to. No criminal violations, had achieved a lot in the mariachi world. Still detained. Both sides, I'm talking there was Republicans and Democrats, both came together asking for their release. Yesterday, finally released, thank goodness. But it just goes to show you that there's a problem out there when people are still following the rules and still being punished for it.
Yeah, I mean, it's good for these 3 brothers, of course, but there are thousands of people being detained in similar circumstances every day, and there's no huge bipartisan support to make them go free. So while it's good for the Mariachi brothers, this is still a major problem with ICE check-ins, and even though you're following the rules, you can still be detained. So if you have an ICE check-in, if you're dealing with ICE at all, the courts, talk to an attorney.
Let's hope that people that see this story, non-criminal violations, following the rules. Let's hope that we did have that bipartisan sort of support to get them released, that they start looking at this on a bigger issue and say, if immigration wants you to follow these rules and you're doing that, what are we doing?
So even outside the rules that you follow, immigration is still detaining you. There are still things you can do if you've been detained. They have made it more difficult. I'm not gonna lie about that, but there's still some things that an attorney can do for you.
For sure. Rapid fire questions. You ready?
Ready.
All right. Can a U.S. citizen child petition for their parents?
Yes, but it can be complicated. A U.S. citizen child who's over 21 or older can petition for their parents. Now, if the manner of entry of the parents matters a whole lot if they're in the United States, if they enter lawfully, they can file to adjust their status. If they enter illegally, that means the parents are going to need a waiver the child can't sponsor. So the parents would have to leave for 10 years.
Very important point.
Very important point. Military service kind of gets around that issue, but that's about the only thing it does.
So a lot of people, when they have immigration court coming up, there's a lot of trepidation. So you see them reaching out saying, can I have my hearing by video? Can I possibly move that hearing? I don't want to go. What's the current situation?
So in terms of moving the hearing, I don't want to go is not a valid legal reason to move your hearing. Understandable, but no, you can't move your hearing because of that. For the video hearing, it really just depends on the judge. Some judges are video only, some judges are in person only, and depends on what judge you get.
One of the things I think is important here is that, earlier this year last year, there was a lot of worry that people were getting detained when they went to court. That seems to have subsided. That's not really going on, particularly here in Texas.
I have not seen that or even heard about that if you go to your master hearing or individual hearing with an attorney. So I think that fear is way overblown here.
Absolutely. I get this question a lot. I know you get this question a lot. People come into our office seeking a consultation, And understandably, they want to try to get status of some
Right.
sort. They don't really know the laws and the rules. You know, they have ties to the U.S. Maybe they have children at home.
Right.
They've been in the U.S., say, 10, 15 years, something like that. That's what they have. And they say, hey, based on these things, are they eligible for anything?
Usually not. There are some things where possibly, but time by itself does not get you status. That's just you've managed to not get caught by ICE while you've been here, but that doesn't mean they're going to give you a green card just because you managed to outlast ICE for 10, 15, 20 years.
Thanks for joining us on the Deposition this week. Thank you, Attorney Lewis.
Thanks for having me.
See you guys next time. God bless.